I see it my way. Yes, it goes, yes and no.
This is the update that was filed on the 14th the other day. I read the government's motion, but I didn't go back. After that, he uploaded the his reply, and I just wanted to keep it here on the channel of Spitting Fire. Okay. I really do need to be putting this on the MIB over there, but I'm just going to put it over here for now. Okay. It's the reply to the United States response to the motion to vacate judgment. The government response offers no substantial rebuttal to Mr. Kelly's motion to vacate. For one, the United States cites Federal Rule Civil Procedure 41B in arguing that the dismissal was appropriate, docket 458 at 1. But Rule 41B empowers the defendant to file a motion for dismissal, not a district court, okay, sua sponte dismissal of an action. So this must mean something, and I don't know what that means right now. So what I'm going to do here is I'm going to, as I read this, I'm going to try to do it a different way so that I can educate myself on it, okay? Because I don't speak like this, and it's just what you do. It says is a Latin term meaning one own accord or voluntarily. All right. So this is what this means. So let me show you what that means. Okay. It's a Latin term. Okay. Now, you see how I tell you it don't be us sometimes. It be the folk who wants, let me see. I'm going to do like this, right? And then it's right here, right? You see that? That is what that word means. It's a Latin term meaning one owns accord voluntarily. In a legal context, it refers to judge taking action in a case without being prompted by either party. Essentially, it means the court is acting on its own initiative rather than responding to a motion or requests from lawyers involved. Okay. Dismissal of an action. Okay. Federal Rule Civil Procedure 41B. If a plaintiff fails to prosecute or to comply with the rules or a court order, the defendant may move to dismiss the action or any claim against it. Emphasis added. No defendant filed a motion to dismiss or failure to prosecute in this case. Okay. The court does, of course, possesses inherent authority to sua sponte order of dismissal of an action for failure to prosecute. Okay, like this case law here. However, the Second Circuit has cautioned that federal courts, through they possesses inherited powers, must exercise these powers with restraint. Graham versus Shoemaker case law. This is especially true if the court uses ultimate sanctions of dismissal, default, or its equivalent. Okay, Kovalik Construction Company versus Miss Brenner. Okay, case law. Moreover, this case is relatively young case, and a dismissal with prejudice is particularly disfavored with relatively young cases, such as the one before us, Weber versus Court case law, reversing the dismissal with prejudice where the case was barely 18 months old when dismissed by the district court. The United States does not argue that it was prejudiced in any way by dismissed deadline or that there have been any meaningful impact on the litigation. Given the absence of the prejudice in the defendant and that the fact that the plaintiff's tardiness, while careless and regrettable, was not egregious. Okay. Both voices versus Lloyd case law. Lesser sanctions would have been more appropriate in this instant if no meaningful impact upon the case of the litigation has been shown. Okay. As it is in this case here, the drastic sanctions of dismissal and judgment should be reversed for conducts of events is more intense regarding for the court. Okay, Burnhill versus United States case law. He doing a lot of case laws. He's throwing them in there, y'all. He is throwing them in there. Okay. Mr. Kelly understands that the court concerns is disposing of its caseload expeditiously. Weber versus I Corp case law, and the undersigned reiterates his apologies to the court for that delay. However, justice is often impaired by such close, inflexible attention to the docket. Okay. And then we got this case law here. And in the Seventh Circuit, there is a well-established public policy favoring hearing case on the merits. Okay. Plaintiff failed to meet the initial deadline after prior counsel abrupt and unexpected exit from the case was admittedly negligent. Ooh, talking about Bonjean. However, most recent missed deadlines was not out of any sort of disregard of the courts of any judicial process. The undersigned was experiencing a legitimate and life-threatening medical emergency that renders him unable to work. A copy of the emergency room record and tramadol prescription he received are attached. Okay. So they did show that. I'm just not showing that here on my channel. Okay. The lack of substance in the United States response is telling. It is simply trying to capitalize on the missed status report to evade the case that is clearly meritorious. Okay, so that means it has merit. A Bureau of Prisons employee clearly stole and disseminated Mr. Kelly's responses. The United States is simply trying to evade accountability for this transgression. And Mr. Kelly respectfully asked that it not be permitted to do so, and that the court hear the case on the merits. Respectfully submitted, Bo Brentley. So he definitely did his thing here. And then that will be it. All right. That's just a quick update. And I just wanted to bring you that because the last thing I talked about was the government's response. All right. Until next. Please like, subscribe, and hit the notification bell so you know when I upload a new video. Fire out.